Gerald Morrow spent 4 months coordinating a share issuance designed to take my 40% stake down to 11%, and in all of that time, nobody checked Section 6.1. I want you to hold that number for a second. 40% of a company I helped build from a leased office above a print shop in 2013. $12,600,000 in equity at the 2019 valuation. 6 years of late nights, 3 product pivots, 2 near bankruptcies, and 1 very specific binder with a blue cover sitting on the bottom shelf of my home office, Section 6.1 tabbed in yellow because my attorney had walked me through it the day we signed. Gerald did not check that binder. Gerald did not believe he needed to. He believed I had grown comfortable. He believed I had gotten quiet. He believed that a board chairman with 3 minority investors in his pocket could issue 2,400,000 new shares as a strategic growth round, and that the founder, the woman whose name was on the original certificate, would simply absorb the dilution and move on to whatever quiet retirement he had pictured for me. What he did not know, what none of them bothered to verify, was that the founding shareholder agreement we had executed in 2013 contained a pre-emptive rights clause that gave me the right to maintain my proportional ownership on any new issuance. No waiver, no notice, no vote. The issuance he engineered was not aggressive. It was not clever. It was legally defective from the moment it was signed. But I did not say that in the room. Not on the day they voted. Not on the day the new cap table circulated. I said almost nothing for 30 days, while my attorney drafted a declaratory judgment filing, and the binder sat on the conference table between us. If you have ever watched people mistake experience for weakness, stay with me. And if this story speaks to you, subscribe to my channel for more stories like this, because in business, quiet records can speak louder than any argument. My name is Sophia. I am 61 years old. I co-founded ReedBridge in 2013 with 2 other people, one of whom is no longer with us, and one of whom sold his shares back to the company in 2017 and retired to a lake house in Wisconsin. By the start of 2019, I held 40% of the equity, which on paper was worth about $12.5 million, and I had a board of 7, including myself, 3 minority investors who had come in during the Series A, 2 independent directors, and the chairman, Gerald Morrow. Gerald was 52 when he joined the board. Polished, fast-moving, the kind of man who used the word leverage as a verb in casual conversation. He had been recommended by one of our Series A investors as someone who could professionalize the governance side of the business. I remember the first meeting we had after he joined. He told me, with what he must have thought was charm, that I had built something remarkable, and that his job now was to make sure it scaled past my comfort zone. I smiled. I nodded. And I made a note in my own calendar that night that read simply, "Watch this one." That note ended up in a folder I kept on my desk for the next 6 years. The first thing you should understand is that I am not, by nature, a confrontational person. I built ReedBridge by listening more than I talked. I won contracts because I read every line of every agreement before I signed. The blue binder, the founding shareholder agreement, lived on the bottom shelf of my home office, not because I forgot about it, but because I had read it so many times in 2013 and 2014 that I knew exactly where Section 6.1 was. My attorney at the time, a woman named Elaine, who had since moved to a smaller firm, but still took my calls, had spent 2 hours walking me through the pre-emptive rights clause the day we signed. She had said something I never forgot. She said, "Sophia, this clause is the reason you keep what you build. If anyone ever tries to issue new shares around you, this is the page you open." I tabbed it in yellow that afternoon. In early 2019, the first thing I noticed was the calendar. That was the first agenda item I saved. Gerald began scheduling investor calls that I was not invited to. Not all of them. Just enough that, looking at it casually, you might assume it was a scheduling conflict or a topic that did not require the founder's input. But I keep a clean calendar. I always have. And by the second week of February, I had counted 4 separate investor conversations on Gerald's calendar that included 2 of our 3 minority investors and excluded me. The invites were titled things like quarterly check-in and capital review prep. Innocuous on the surface. coordinated when you lined them up. I did not say anything about it then. I noted the dates. I saved the calendar invites in a folder on my own machine. I told Elaine over the phone, very casually, that I might have a small governance question for her in the coming months, and asked if she could keep some time open. She said, of course. That was red flag number 1. Red flag number 2 arrived in April. I received an updated cap table from our internal finance team. It was a routine quarterly distribution. I almost did not open it on the day it came in because I was traveling for a customer visit. But that night, in the hotel room, I pulled it up on my laptop and read through the columns. Everything looked correct, except for one new line item I did not recognize. There was a reserved pool of unissued shares listed at $2,400,000. No board resolution attached, no memo explaining the purpose of the pool. Just a line item slipped into the cap table as though it had always been there. I emailed our finance director that night and asked, very politely, where the authorization for the reserved pool had come from. He replied the next morning that it had come from the chairman's office and that he had been told it was a placeholder pending board action. He apologized for not flagging it on the cover memo. I told him not to worry about it. I told him I would follow up with Gerald directly. I did not follow up with Gerald directly. I called Elaine. I told her about the calendar invites. I told her about the reserved pool. I told her about Gerald's general posture toward me over the past several months. The small things. The way he had begun cutting me off in meetings. The way he had started referring to my role as the historical voice of the company. Elaine was quiet for a long time. Then she said something I have thought about often since. She said, "Sophia, you do not have a problem yet, but you may have one soon. Pull the founding shareholder agreement off the shelf and read section 6.1 again tonight, and then put it somewhere you can find it quickly." I drove home from that customer visit 2 days later. I went into my home office. I pulled the blue binder off the bottom shelf. I opened it to section 6.1. The yellow tab was still there. I read the clause 3 times. Then I set the binder on top of my desk, where it stayed for the next 6 months. I want to tell you something about my home office. The bottom shelf of the right-hand bookshelf is where I keep the foundational documents, the articles of incorporation, the original employment agreements, the shareholder agreement, the letter Elaine wrote me on the day we closed the formation in 2013, congratulating me and reminding me that the documents on that shelf were, in her words, the architecture of my career. I sat in my leather chair that night. I read section 6.1 again. I read the surrounding sections, the definitions, the boilerplate, the signature page. I closed the binder. I sat there for a long time without moving. Then I called Elaine to confirm I had pulled the right document. I also called a friend named David, a retired corporate counsel, to ask, hypothetically, whether a board could authorize a substantive share issuance without a pre-read. He laughed. He told me, gently, that he had been waiting for the day I would call him with this kind of question. He told me to keep my powder dry. The email looked ordinary until I read the attachment. That came in late May. Gerald sent a board-wide note announcing that the next regular board meeting, scheduled for the second week of June, would include a capital structure review as part of the agenda. The body of the email was 3 sentences. He thanked everyone for their continued partnership. He said the company was in a strong position to consider strategic growth options. He asked everyone to come prepared. The attachment was a 1-page agenda. Item 3 was capital structure review. There were no supporting materials, no pre-read, no financial models, no commentary. Just the agenda item, sitting between approval of prior minutes and a routine update on the customer pipeline. That was red flag number 3. In all my years on that board, I had never seen a substantive capital matter listed on an agenda without a pre-read. Gerald himself had implemented the pre-read requirement when he joined. He had given a short speech about it during one of his first meetings. He had said, with that smile of his, that good governance starts with informed directors. And now, in May 2019, he was scheduling a capital structure review 3 days out with no materials. I did not raise it on the email thread. I did not flag it to the other directors. I forwarded the agenda to Elaine with a single line. I asked her if she had time for a longer call. We spoke that Saturday morning. She told me to bring the binder. That Saturday call was longer than any conversation Elaine and I had had since the original formation. She walked me through, again, the full scope of Section 6.1. She walked me through the case law on pre-emptive rights in our jurisdiction. She walked me through the procedural posture of a declaratory judgment action, what the timeline would look like, what the evidentiary burden would be, what the likely arguments from the other side would be. She did not pressure me. She did not tell me to file anything. She told me to listen carefully at the meeting on Tuesday, and to take notes, and to not, under any circumstances, raise the pre-emptive rights issue in the room. She said, Sophia, if they do not know about the clause, they will commit themselves on the record. That commitment is the case. I understood her. I understood her completely. I spent that Sunday and Monday going through every email I had exchanged with Gerald in the prior 12 months. I made a list of every meeting that had been rescheduled at his request. I made a list of every conversation in which he had described my role in language that, in retrospect, was not flattering. The historical voice of the company, the institutional memory, the stewardship phase of the business. Phrases that, when you put them together, formed a portrait of a founder being slowly written out of her own company by a chairman who was certain he was modernizing the governance. I was not angry. I was assembling. There is a difference. The room thought I was quiet. The minutes knew I was right. The board meeting took place on a Tuesday morning in June. We met at our offices in the same conference room we had used for every quarterly meeting since 2017. Gerald was already there when I arrived, standing at the head of the table with a cup of coffee, talking to one of the minority investors. He looked up when I came in. He smiled. He said, Sophia, good to see you. He gestured to my usual seat. I sat down. I had the binder with me, in a leather folder, so it did not look out of place. I had it on the chair beside me, not on the table. I had decided that morning that I would not show my hand. Not in that room. Not yet. We worked through the first two agenda items. Approval of the prior minutes. The customer pipeline update. Routine. Polite. Everything moving on schedule. Then Gerald introduced item 3. He said the company had been in strong shape over the past several quarters, and that the board had been discussing, informally, the possibility of raising additional capital to fund a strategic growth initiative. He said that, after consultation with several directors, he believed the appropriate path was to authorize the issuance of 2,400,000 new shares to a strategic investor who would come in at a favorable valuation. He said the structure had been reviewed by counsel and that the documentation was ready for board approval that morning. He distributed a packet, 6 pages, the board resolution, a summary term sheet, a cap table showing the post-issuance ownership. I looked at the cap table. My ownership, on the post-issuance line, was listed at 11%. I want to tell you what I felt in that moment, but I am not going to over-dramatize it, because that is not how I experience things. I felt cold. I felt focused. I felt the specific stillness I have felt in every important meeting of my career, the kind of stillness where my pulse slows down rather than speeds up. I asked one question. I asked Gerald whether the issuance had been reviewed against the founding shareholder agreement. He said yes. He said counsel had confirmed there were no impediments. I asked who counsel was. He named the firm. It was not the firm that had drafted the original shareholder agreement. It was a firm Gerald had brought in the year before for general corporate work. I nodded. I did not press further. I did not pull the binder out of my folder. I did not quote Section 6.1. I let the meeting continue. The vote was called. 5 directors voted yes. I voted no. 1 independent director abstained. The resolution passed. Gerald looked at me across the table. He said, Sophia, I know this is a difficult adjustment, but I want you to know the board believes this is the right path for the company. I want you to feel comfortable that we have done this carefully. I told him I appreciated the comment. I told him I would review the materials in detail and circle back if I had questions. I gathered my folder. I shook hands with each of the directors as I left. I did not raise my voice. I did not show my hand. I drove straight home. I called Elaine from the car. I told her the issuance had passed and that I needed to see her the next morning. She said, "Bring the binder." I did. The next morning, in Elaine's conference room, I set the blue binder on the table between us. Elaine had 2 associates with her, a younger man named Marcus and a woman about my age named Patricia, who specialized in shareholder disputes. They had pulled the relevant case law in advance. Elaine opened it to section 6.1. She read the clause out loud, slowly, the way you might read a sentence in a will. The clause stated, in language I had read so many times I could almost recite it, that the company could not issue new shares without first providing pre-emptive rights notice to existing shareholders proportional to their existing ownership, and that no issuance would be valid without either the exercise or the documented waiver of those rights. There was no waiver. There had been no notice. There had been no offer to me to participate in the issuance proportional to my 40% stake. Elaine closed the binder. She looked at me and she said, "Sophia, the issuance is void." She did not say it dramatically. She said it the way a doctor reads a clear diagnosis. The issuance had been structured around a clause that had been overlooked. The board, regardless of their intent, had voted on something they had no authority to vote on without first complying with section 6.1. The corporate counsel Gerald had brought in had either missed the clause entirely or had not been shown the founding agreement. The board did not vote on what they thought they were voting on. I want you to sit with that. 5 intelligent people, in a conference room with coffee and a printed packet, raised their hands to authorize an issuance they believed was lawful. They were wrong. Not because they were stupid, because they had relied on someone who had not read the document that mattered most. Elaine asked me what I wanted to do. Patricia slid a memo across the table. She had drafted, the night before, a preliminary analysis of the issuance and the relevant statutory framework. 12 pages. Procedural, not dramatic. It walked through the elements of a valid issuance under our state's corporate code, the additional requirements imposed by the founding shareholder agreement, the case law on adequate notice, the case law on implied waiver. Every line pointed to the same conclusion. The issuance was void. I asked Elaine how often this kind of error happened in practice. She said more often than people think. Board chairs and their hand-picked counsel often relied on the corporate code without checking the company's own constitutive documents. She said overlooking those protections was, in her experience, the single most common substantive error in private company governance. She said it almost casually, the way a doctor might describe a common but serious misdiagnosis. I told her I wanted to file for a declaratory judgment. I wanted a court to confirm, on the record, that the issuance was void and that my 40% stake had never been diluted. I did not want a settlement. I did not want a private negotiation with Gerald. I wanted the document, the founding shareholder agreement, to speak in open court. She nodded. She said it would take about 3 weeks to prepare the filing properly. She said we should also send a formal notice letter to the company within the next 7 days, putting them on notice that the issuance was being challenged. I told her to draft the letter that day. That afternoon, before I left her office, I asked her one more question. I asked her what she thought Gerald had been thinking. Not legally, personally. What kind of man arranges a 4-month coordination with 3 investors and forgets to read the founding document? Elaine thought about it for a moment. Then she said, "He thought you weren't paying attention anymore." I drove home that night with the binder on the passenger seat. I want to tell you about the second open loop, the one that turned what had been a single misjudgment into something more deliberate. About 10 days after we sent the notice letter, in the course of preparing the discovery requests that would accompany the declaratory judgment filing, our team requested copies of all email communications between Gerald and the 3 minority investors over the prior 12 months. The company, on advice of its new outside counsel, produced the emails. There were, by Patricia's count, 64 messages. The email thread that mattered was a chain of 7 messages between Gerald and the lead minority investor, a man named Richard, dating from late January through mid-February of 2019. The thread had been titled, innocuously, Growth Round Prep. The first email in the chain was from Gerald to Richard. It was 4 paragraphs. The opening paragraph thanked Richard for his recent call. The second paragraph laid out the strategic rationale for what Gerald described as a meaningful capital raise. The third paragraph, which I read twice, described what Gerald called the founder dynamic. He said that the founder, meaning me, had become a constraint on the company's velocity, that her ownership position gave her, in his words, an outsized voice in matters that required a more disciplined chairmanship, and that the appropriate path forward was a structured dilution that would, over time, restore the board to a more balanced governance posture. The fourth paragraph proposed the 2,400,000 share figure, specifically, down to the share, 5 months before it appeared on the agenda. I read that email in Patricia's office on a Wednesday afternoon. I read it twice. Then I set the printout down on the table, and I asked her to bring me a glass of water. She did. I sat there for about 3 minutes, drinking the water, looking out the window at the courthouse 2 blocks away, and I thought about the phrase outsized voice. I thought about how a founder who had built a company from a leased office above a print shop had been characterized in a private email between 2 men who had arrived after the building was already standing, as a constraint on velocity. I did not feel angry. I felt, more than anything, vindicated about my own instincts. I had known, the night I made that note in my calendar in 2013 about Gerald, that he was a man who would, eventually, do something like this. I had not known the specifics. I had known the type. The email thread continued through 6 more messages. 2 of the messages included the second minority investor on copy. 1 included the third. The thread, taken as a whole, established a coordinated 4-month effort to engineer the issuance, frame it as a strategic growth round, and present it to the board with insufficient pre-read so that the dilution could be voted through before any shareholder would have an opportunity to fully analyze it. The email thread became Exhibit C in the declaratory judgment filing. Section 6.1 was Exhibit A. The cap table was Exhibit B. The emails were Exhibit C. The court would have all 3 before it. I did not file a separate claim for breach of fiduciary duty. Elaine and I discussed it. We could have. The emails would have supported it. But I had decided by then that the cleanest path was the narrowest one. The declaratory judgment would void the issuance. The voiding of the issuance would restore the equity. The restoration of the equity would moot the larger question of damages. And the larger question of damages would, in any event, have required a longer, more public, more bruising process. I did not want bruising. I wanted accuracy. Some people lose a company because they never read the clause that gave it to them. Gerald, as it turned out, was about to lose his chairmanship because he never read the clause that protected mine. The notice letter went out 4 days later. It was 3 pages. It was unemotional. It identified the issuance, cited Section 6.1, attached a copy of the relevant page of the founding shareholder agreement, and stated that absent prompt voluntary rescission, the founder would be filing for declaratory relief within 30 days. I was copied on the letter. So was every member of the board. So was the corporate counsel Gerald had retained. I did not get a phone call from Gerald that day. I did not get one the next day either. What I got on the 3rd day was a meeting request. He asked if I would meet him for coffee at a place near our offices. He framed it as a conversation between colleagues. He said he wanted to clear up any misunderstandings before things became unnecessarily formal. I declined the meeting. I told him, in a brief reply, that I appreciated the offer, but that all communications going forward would be handled through counsel. I attached Elaine's contact information. I signed the email with my full name. That email was the last direct communication Gerald Morrow and I ever had. The week after the notice letter, the corporate counsel he had retained sent a response. The response was, by any honest reading of it, an attempt to argue that the preemptive rights clause had been impliedly waived by my conduct over the years, on the theory that I had not exercised preemptive rights on prior small issuances, and that this established a course of dealing. Elaine read the response in our next meeting. She put it down on her desk. She told me it was not a serious legal argument. She told me she had seen the like before, from firms in over their heads, who had been hired to clean up something they should have prevented. She said the course of dealing theory required the prior issuances to have been substantively similar in size and impact, and a 2,400,000 share dilution from 40 to 11% could not, by any stretch, be characterized as similar to the small option grants we had done over the years. She said we would file the declaratory judgment action the next week. That was on a Monday. The filing went in on Thursday. I read it that night. It was 22 pages. It walked the court through the formation of the company, the execution of the founding shareholder agreement, the language of Section 6.1, the timeline of the calendar invites, the reserved pool, the agenda, the meeting, the vote, the cap table. It attached the founding shareholder agreement as Exhibit A, with Section 6.1 highlighted in the same yellow tab I had used for 6 years. I want to tell you something about that filing. When I read it, I did not feel triumph. I felt clarity. I felt the way you feel when you have been carrying something for a long time and you finally set it down on the right surface. The document was speaking now. I did not need to. The case moved faster than most people expect these cases to move. That is partly because the legal question was narrow. There was no factual dispute about whether the issuance had occurred. There was no factual dispute about the language of Section 6.1. There was no factual dispute about the absence of a waiver. The only question for the court was whether the issuance, undertaken without compliance with the preemptive rights clause, was valid. It was not. The court issued its ruling about 10 weeks after the filing. The ruling was 11 pages. It found plainly that the issuance was void for failure to provide the required preemptive rights notice. It ordered the company to rescind the issuance, restore the cap table to its pre-issuance state, and reflect the restoration in all corporate records. My 40% stake was reinstated. The $12,600,000 in equity was fully restored. The 2,400,000 new shares Gerald had issued evaporated, on paper, the moment the ruling was filed. I want to be honest about what happened next, because it is the part of these stories that people tend to dramatize, and I am not going to. There was no scene, there was no confrontation, there was no moment in which I walked into a boardroom and read the ruling out loud while Gerald Morrow turned red. The ruling was distributed by the court. It was reviewed by counsel for the company. It was placed on the agenda for the next regular board meeting, which fell about 3 weeks after the ruling was issued. I attended that meeting. I sat in my usual chair. The binder was in the leather folder beside me, as it had been at every meeting since June. The board chair, on Gerald's recommendation, asked the company's general counsel to read the operative paragraphs of the ruling for the record. The general counsel read them. He read the paragraph that found the issuance void. He read the paragraph that ordered the cap table restored. He read the paragraph that confirmed my 40% stake. When he finished, the room was quiet for what I would estimate at 15 seconds. It was the longest 15 seconds in the history of that conference room. Gerald did not look at me. He looked at his packet. The chair, after the silence, said simply that the board would, of course, comply with the ruling, and that the cap table would be updated by the end of the day. He moved to the next agenda item. The meeting continued. We talked about the customer pipeline. We talked about a new hire in marketing. We talked about a routine vendor renewal. I did not say anything about the ruling. I did not need to. 6 weeks after that meeting, Gerald Morrow resigned from the chairmanship. The resignation was framed in the public announcement as a personal decision to pursue other opportunities. It was not. The 2 independent directors had spoken with the minority investors in the weeks following the ruling. There was no formal vote to remove him. There did not need to be. Gerald understood by then that his position was untenable. The directors who had voted with him in June had, in private conversations, made it clear that they would not support him in any future contested matter. He sent a brief letter of resignation. He thanked the board for the opportunity. He wished the company well. He did not call me. I did not expect him to. The new chair was elected from among the independent directors. She was a woman in her late 50s named Helen, who had joined the board the year before and who had abstained on the June vote. I want to tell you why she abstained, because I asked her about it later, after she became chair, in a private conversation over coffee. She said she had felt, at the time of the vote, that something was off. She had not been able to articulate it. She had not seen the founding shareholder agreement. She had not been told about the calendar invites or the reserved pool. She had simply noticed that I was unusually quiet in that meeting. She said in her experience, when a 40% founder gets that quiet, it is not because they have nothing to say. It is because they are choosing not to say it yet. She said her abstention was not a vote of confidence in me. It was a vote of caution. But she said, looking back, she was glad she had abstained. I told her I was too. I want to tell you about the months between the ruling and Gerald's resignation, because they were, in their own quiet way, the part of the story I think about most often. After the ruling came down, I continued to attend every regular and special board meeting. I did not skip any. I did not delegate any. I was 40% of the company again, on the record and in the cap table, and I was determined that my presence in those meetings would be unmistakable. Gerald, during those weeks, was professional in a way that bordered on theatrical. He greeted me at every meeting. He asked, in general business terms, for my views. He nodded at my comments. He never once referenced the ruling or the litigation. He acted as though the issuance had simply not happened, as though the prior summer had been a procedural hiccup. The other directors did not play along quite so smoothly. Helen, the independent director who had abstained, asked clarifying questions in those meetings that, looking back, were probably designed to put certain things on the record. The two minority investors who had voted with Gerald in June were noticeably quieter. The third minority investor, who had not been on the email thread, began speaking up more often, which was its own kind of signal. The pressure, when it came, did not come from me. I had decided, after the ruling, that I would not be the person who drove Gerald off the board. The board would do that itself. I had made my point in court. I did not need to make it again in the conference room. It took 6 weeks. There was a quiet conversation between Helen and the lead minority investor. There was a follow-up conversation between the lead minority investor and Gerald. There was, I am told, a single phone call between Gerald and his original sponsor on the board, the man who had recommended him in 2014, in which the sponsor told him, plainly, that the support he had relied on was no longer there. The resignation letter arrived on a Friday afternoon. Helen sent it to the board late that evening with a brief cover note, asking everyone to please review and confirm that the letter would be accepted at the next regular meeting. I read the letter once. I forwarded it to Elaine without comment. I went to bed. I want to take a moment, before I tell you about Maya, to talk about the binder. The blue binder, the founding shareholder agreement, sat on the bottom shelf of my home office for 6 years before I needed it. It moved to my desk in May 2019, the night Elaine told me to find it. It traveled in my leather folder to every meeting between June and the ruling. It sat on the conference table at Elaine's office during our planning sessions. It was the Exhibit A on the court filing. It was, in a quiet way, the only voice that mattered in the entire dispute. After the ruling, I took the binder home. I cleaned the yellow tab on section 6.1. I put the binder back on the bottom shelf of my home office, in the same spot it had occupied since 2013. It is still there. I tell people sometimes that the most expensive thing in my house is a 6-page section in a 2013 contract. They laugh because they think I am being dramatic. I am not. The preemptive rights clause in that document was worth, on the day of the ruling, $12,600,000. It was worth more than that, actually, because of what came next. 2 years after the ruling, in 2021, I set up a family trust. The trust was funded primarily by the equity stake that had been restored by the declaratory judgment. The trust has a number of provisions, but the one I care most about, the one I want to tell you about, is the provision that funds the education of my granddaughter Maya through the age of 25. Maya is 8 years old at the time I am telling you this. She likes horses and a particular kind of complicated math problem that I do not fully understand. She does not know yet what the family trust is or where it came from. She does not know about the binder. She does not know about Gerald Morrow. She does not know about the 11% line on the cap table that, for 30 days in 2019, was the official record of her grandmother's ownership in the company her grandmother built. She will, one day. When she is old enough to ask, I will tell her. I will pull the binder off the shelf. I will open it to section 6.1. I will explain to her, the way Elaine explained it to me in 2013, that this is the page that keeps what you build. I will tell her that the trust that pays for her education exists, because in 2019, a chairman she will never meet decided to issue 2,400,000 shares without reading the document that made the issuance impossible. I will tell her that her grandmother did not raise her voice in that boardroom, that her grandmother let the document speak, that her grandmother understood by then what it had taken her a lifetime to learn, which is that the quietest person in the room is sometimes the one holding the minutes. I want to talk briefly, before I close, about what I learned from this. Not the legal lesson. The legal lesson is obvious. Read your founding documents. Tab the clauses that protect you. Keep the binder on the bottom shelf of your home office where you can find it. The other lesson is harder. Gerald Morrow was not, I think, a particularly malicious man. He was an ambitious one. He was a man who had been told, by people he respected, that I was a founder who had become comfortable, who had grown attached to old structures, who needed to be carefully moved aside so that the company could scale. He believed that story. He believed it so completely that he spent 4 months coordinating an issuance designed to act on it, and he never once thought to verify whether the legal foundation of that story was real. That is the part that stays with me. Not the betrayal itself, the certainty. There is a version of this story in which I confronted Gerald the morning after the vote. There is a version in which I called the other directors, one by one, and tried to win them back. There is a version in which I sent a long, indignant email about my contributions to the company. None of those versions would have produced the ruling. None of those versions would have restored the equity. None of those versions would have funded Maya's education. The version that worked was the one in which I drove home from the meeting, called my attorney, and let the document do what the document was written to do. I am not telling you that you should never raise your voice. I am telling you that, when the document is on your side, the document does not need your voice. It needs your patience. I have been on 3 boards in the years since. I have read the founding documents of each one before I joined. I have asked, in each case, where the original signed copies are kept and who has access to them. I have made sure, in each case, that the clauses that protect the founders and the long-term shareholders are clear and current. I have also made it a habit, when I sit in board meetings, to watch for the quiet ones. The founder who has stopped pushing back. The senior executive who has gone silent on contested topics. The shareholder who has not asked a question in 2 meetings. I do not assume those people have nothing to say. I assume, more often than not, that they have read something the rest of the room has not bothered to read. I assume there is a binder somewhere, on a bottom shelf, with a yellow tab. If you have ever felt invisible in a room where decisions were being made about something you built, I want you to hear me clearly. You are not invisible. You are simply not yet on the page where the document begins to speak. That page is coming. It almost always comes. And when it does, the people who have spent your career underestimating you will discover, in a very polite and very formal setting, that they have been telling themselves a story the records do not support. That is the lesson I would leave you with. Not that betrayal is rare, not that boards are cruel, not that ambition is dangerous. Those are all true, in their ways, but they are not the lesson. The lesson is this: the records are written down for a reason, The clauses are tabbed for a reason. The quiet founders, the experienced executives, the long-tenured employees, the patient shareholders have all read something the rest of the room has not. They are not weak. They are not finished. They are simply waiting for the moment when the document is allowed to speak. When that moment comes, it does not need to be loud. It does not need to be dramatic. It needs only to be accurate. And accuracy, in business, is the loudest sound there is. If you have made it this far, thank you for staying with me. I know this story is not the kind that comes with shouting matches or dramatic exits. I told it the way I lived it, which is to say, slowly, carefully, and with the binder always within reach. And if stories like this remind you that experience is not weakness, subscribe to my channel for more stories. Because sometimes the quietest person in the room is the one holding the minutes. I want to leave you with one question before we close. Have you ever had a financial interest in a company reduced or restructured in a way that was later found to be unauthorized? And what was the document that said so? Tell me in the comments. Not the company name, not the people, just the clause, just the section number, just the document that, when it was finally read in the right room, spoke louder than anyone who had tried to speak over you. I will read every reply. I always do. Thank you for listening. The binder is back on the shelf. Section 6.1 is still tabbed in yellow. And Maya, somewhere in another room, is working on a math problem she will probably solve before I do. That, in the end, is what the document was for.